Hi everyone. On the 31st of August 2020, the Irish Government introduced Statutory Instrument number 326 of 2020, the purpose of which is to 1. Limit the number of people attending indoor and outdoor events. 2. Continue current restrictions in relation to access to businesses or services selling alcohol for consumption on the premises unless a substantial meal is ordered. 3. Provide that businesses and services where alcohol is sold for consumption on the premises record information for the purposes of contact tracing. And 4. Provide that businesses and services where alcohol is sold for consumption on the premises close at 11:30 p.m. Now, some people may consider these measures an appropriate response to reports that there have been an increase in the numbers of infections detected over the past week. To this I say, the initial infringements on our freedoms which commenced in April of this year were designed, we were told at least, to flatten the curve. Do you notice that that term is no longer used? And the reason it is no longer used is because flattening the curve is no longer the objective of the government. It would appear that the goal is now the achievement of zero COVID infections. Ask yourself if this is realistic or reasonable, and whether you are happy for your freedoms to continue to be eroded to endeavour to achieve an unattainable goal. To put the erosion of your freedoms into context, on the 31st of August, the day that this regulation was enacted, we had 6 confirmed cases of COVID-19 in critical care units and 0 COVID deaths. Do you consider this a crisis worthy of decimating your freedom to assemble, your right to earn a living, your right to privacy, and so on? I apologise if I seem particularly incensed, but I cannot rationalise how we've allowed the government to presume that they may erode our rights to this extent, while at the same time there only being 6 people in ICU with the very disease they tell us is a pandemic. So the purpose of this video is to review Statutory Instrument 326 of 2020. So let's now take a closer look at the regulation. The regulation is split over 14 sections as follows. Section 1 deals with dates of operation, which for all sections, with the exception of sections 11.3, 12, 13 and 14, is said to be the 31st of August 2020, and for sections 11.3, 12, 13 and 14 is said to be the 3rd of September 2020. Section 2 confirms that the regulations shall remain in force until the 14th of September 2020. This date would appear relevant given that the government have signalled their intention to make known their plans for how COVID will be dealt with in the medium term on this date. Section 3 revokes Statutory Instrument number 234 of 2020, which statutory instrument provided that indoor events could hold 50 persons and outdoor events could hold 200 persons. Section 4 is the definition section. The only definition worth noting in this video is the definition for a relevant venue, which includes A. An auditorium, B. The National Concert Hall, C. Cinemas, D. Art galleries, and E. Museums. Section 5 deals with restrictions on events in private dwellings. So we heard a lot over the past few weeks about the government intending to give Gardaí powers to enter private dwellings and criminalise those in attendance if the numbers in private dwellings exceeded 6 people. This section 5 confirms that a person may not organise an event in a private dwelling for social or recreational purposes where more than 6 people are in attendance and from more than 3 different households. Noting that this number of 6 persons excludes persons ordinarily residing in the private dwelling. This section 5 is not noted as being a penal provision, meaning that no fine or criminal prosecution will attach to non-compliance with restrictions on events in private dwellings. That said, the government has repeatedly made reference to a failure to comply with this section of the regulation as being a civil offence. When the government say this, they are referring to section 43 of the Health Act 1947, which deals with presumption in civil actions as to the cause of infection. When the government say this, they are referring to section 43 of the Health Act 1947, which deals with presumption in civil actions as to the cause of infection. This section 43 provides that if a person allows more than 6 people to attend a social or recreational gathering in a private dwelling, and a person attending the gathering becomes infected with COVID-19, the person organising the gathering may be sued for damages in a civil action. And this is the stinger part. the court will presume that the person infected with COVID-19 caught the disease at the gathering as a direct result of the person organising the event breaching the law, and the onus on proving otherwise shall rest with the person organising the event. I find this to be a very coercive measure and one that will likely assist the government in achieving their aim to quell social gatherings in homes. The next section is section 6, and this deals with restrictions on certain events. This is the section that I believe the government intends to use to try to scare the public into believing that they do not have a right to protest in large numbers. Section 6 states that a person shall not organise an event for social, recreational, exercise, cultural, entertainment or community reasons other than in accordance with Section 6.2. Section 6.2 is the most important piece of this regulation in my view, and provides that a person may organise an event for social, recreational, exercise, cultural, entertainment or community reasons where the person organising the event takes all reasonable steps to ensure that persons attending the relevant event are organised into groups of 6 persons where the event is held indoors or 15 persons where the event is held outdoors. So let's analyse why Section 6 does not restrict the numbers attending political protests. 1. The restriction on certain events only applies to relevant events, and we know from Section 6.4 a relevant event is an event held in the state of Ireland for social, recreational, exercise, cultural, entertainment or community reasons, and excluding certain types of events such as A. Events held at relevant venues, and we know from the definition section this includes events held at auditoriums, the National Concert Hall, cinemas, art galleries and museums. B. Events held in private dwellings. C. Wedding receptions. D. Training events. And E. Sporting events. So unless your event is considered a social, recreational, exercise, cultural, entertainment or community event, no restrictions apply to it. Therefore, the meanings of these words is extremely relevant. So let's take a brief look at the Oxford Dictionary definitions for the following. 1. Social means connected to activities in which people meet each other for pleasure. 2. Exercise means physical or mental activity that you do to stay healthy or become stronger. 3. Cultural means connected with the culture of a particular society or group, its customs, beliefs, etc. 4. Entertainment means films, music, etc. used to entertain people, and entertain means to interest somebody or make somebody laugh in order to please them. And 5. Community means all of the people who live in a particular area when talked about as a group. So in terms of the definition for relevant event, the only event type that raises any questions is the word community. The second reason I believe Section 6 does not restrict the numbers attending political protests is if a person were to initiate a legal challenge against Statutory Instrument 326 of 2020, they would argue that the right to peaceful assembly of citizens and the duty on the state to protect and vindicate the rights of citizens through the restrictions set out in this regulation hold equal weight, in which case the court must consider the reasonableness and proportionality of the restrictions. In this regard, it is my belief that a court would not find it reasonable or proportionate that a wedding could proceed with 50 people in attendance in accordance with Section 8 of this regulation, or that a sporting event could proceed without restriction on number, but on the condition that only necessary persons attend the sporting event in accordance with Section 9 of this regulation, while at the same time the constitutionally protected right to peaceful assembly could only proceed with 15 people in attendance at outdoor events. And the third reason why I do not think Section 6 restricts the numbers attending political protests is due to Section 6.2a's reference to relevant events being organised into groups. So if we look at this section again, the restriction on relevant events requires that event organisers must take all reasonable steps to ensure that those attending outdoor events are organised into groups of 15 persons, and that those groups do not commingle, associate or otherwise come into physical contact with any other group at the event. Therefore, if event organisers were, say, to mark out boxes on the footpath which allowed 15 persons to stand together, It appears to me that this would satisfy the condition under section 6.2, notwithstanding the fact that the event may not even be a relevant event to begin with. Section 7 deals with restrictions on events in relevant venues, which we know from the definition section includes events held at auditoriums, the National Concert Hall, cinemas, art galleries and museums. This section provides that a person may organise events in relevant venues where the numbers in attendance do not exceed 50 people. Section 8 deals with wedding receptions and provides that a person may organise a wedding reception other than in a private dwelling, provided the maximum number of persons in attendance does not exceed 50 persons. Section 9 deals with restrictions on sporting events and provides that a person shall only organise a sporting event which is attended by necessary persons. This section also defines what a necessary person is and what a sporting event is. Section 10 deals with restrictions on training events. The restrictions as to numbers under this section are similar to the restrictions placed on certain events under Section 6, so I do not propose to go into this information any further. Section 11 deals with carrying on or provision of certain businesses or services. This section provides for the continued closure of the following types of businesses. A. Nightclubs. B. Casinos and private member clubs where gambling takes place and which is operated on a commercial basis. C. Any business or service selling alcohol for consumption on the premises unless a substantial meal is both ordered and consumed. This section 11 also defines what a substantial meal is. This section 11 further provides for the closure of businesses and services which sell alcohol for consumption on the premises by 11:30 p.m, provided however that such businesses are permitted to allow members of the public order and collect food or non-alcoholic beverages for consumption off the premises after 11:30 p.m. I really want to ask at this point whether you see a pattern here regarding an agenda by the government to limit alcohol consumption in social settings. When I have raised this issue previously, a number of people have asked me if I found it hard not to drink alcohol or stay out of pubs in order to protect other people. So to be clear, I don't drink alcohol and have not done so for more than 20 years, so my aversion to these restrictions has nothing to do with a desire to drink in pubs, but has everything to do with the owners of such establishments having a constitutionally protected right to earn a living, with which the government has no right to interfere without a referendum. Section 12 deals with restrictions on businesses and services that do not sell alcohol for consumption on the premises, and provides that such businesses and services shall not allow persons access to their premises after 11:30 p.m, except for the purpose of ordering or collecting food or non-alcoholic beverages for consumption off the premises. Section 13 deals with further requirements placed on premises where alcohol is sold for consumption on the premises and provides the following. A. In the case of a party of persons, the venue must make a record of the date, time, name and phone number of the lead person. B. In the case of a single person, the venue must make a record of the date, time, name and phone number of the person. C. The venue must make a record of the substantial meal ordered by the person or groups of persons. D. The venue must not allow food or beverages to be sold to a person unless the food and beverages are consumed in accordance with Section 11, so this is the reference to a substantial meal, and provided the food and beverages are consumed by the person while seated at a table. Yes, you heard me correct, while seated at a table. And E. Records such as date, time, name, phone number and meal ordered must be kept for 28 days and made available to the Gardaí for inspection and the HSE for contact tracing. Note quite importantly that data such as date, time, name, phone number and substantial meal is not collected in venues that do not sell alcohol for consumption on the premises. When you consider this point alone, I ask you if you still think these restrictions are about preventing and minimising the spread of COVID-19. From my point of view, I find the restrictions set out under this regulation to be the most coercive and misleading to date, given that most people did not take substantial issue with the lockdown measures in early April due to the numbers of infections and deaths being published at that time. However, when this regulation was enacted on the 31st of August 2020, there were only 6 people in ICU with COVID-19. There must come a point at which we allow the economy to reopen and our children to go back to their normal lives without fear and panic. Unless, of course, fear and panic is the ultimate goal. Throughout this pandemic, one quote has always sprung to my mind. That is the quote by John Adams, where he said, "Fear is the foundation of most governments." Thanks for listening.